Thanks to Shopify for supporting Future Hindsight. Shopify is a platform designed for anyone to sell anywhere, giving entrepreneurs like us the resources once reserved for big business. Sign up for a $1 per month trial period at shopify.com/hopeful, all lowercase. Welcome to Future Hindsight, a podcast that takes big ideas about civic life and democracy and turns them into action items for you and me. I'm Mila Atmos. It's 2024, and the future of America is in your hands. Democracy is not a spectator sport, so we're here to bring you an independent perspective about the election this year and empower you to change the status quo. We love to learn about new ideas that bolster democracy, ranging from election reform to political philosophy and constitutional amendments. We're long overdue for a fresh way to interpret the Constitution. After decades of originalism's ascent, it's time to break free and embrace a new way: inclusive constitutionalism. It's a framework that builds democracy with equal membership for all. Our guest is Madiba Dennie. She's deputy editor and senior contributor at the critical legal commentary outlet Balls and Strikes. As an attorney, columnist, and professor, her work focuses on fostering an equitable multiracial democracy. And her debut book, The Originalism Trap: How Extremists Stole the Constitution and How We the People Can Take It Back, is out now. Welcome, Madiba. Thank you for joining us.
Thank you so much for having me.
It's super exciting that you have put forth a new way for how the law interprets the Constitution. And I know that sometimes people don't get to the end of the episode, so I just want to cut straight to the punchline here. What is inclusive constitutionalism?
Solid opening question. So by inclusive constitutionalism, I think the most foundational point would be that the Constitution includes everyone, all of the country's residents. And so our constitutional interpretation should work in a way that makes inclusive democracy real. That is not the case right now, nor has that really ever been the case. The Constitution's provisions have never really been actualized in a way that works for everyone. And I think that is a mistake, both morally, but also legally, if you look at the text of the Constitution itself. The whole point of the Reconstruction Amendments was to foster this kind of multiracial democracy for the first time. These were the amendments that were enacted in the wake of the Civil War and tried to address the status of newly freed, formerly enslaved people. And so for the first time, we got a constitutional commitment to an expansive multiracial democracy. And I think that that is the lens that we should be applying to all of the Constitution. So when we're applying any of the Constitution's provisions, we should think about what do these mean in light of the liberatory goals of the Reconstruction Amendments.
Mm-hmm. So tell us a little bit about how inclusive constitutionalism will achieve this vision of this goal.
Right. So something you said at the beginning that stood out to me was that democracy is not a spectator sport. And I think that that's a big part of inclusive constitutionalism as well, that it really is for everyone and encourages the public to think about what the Constitution means. Right now, the Constitution is interpreted basically only by the Supreme Court. That is a relatively new phenomenon. It has not always been the case that only the court would say what the law means. Like, there's been some political contestation throughout American history. But now it's as if that sole responsibility has been left to the Supreme Court alone. And so I think that there is a role for the public to articulate what it believes the Constitution means, especially through this frame of the Reconstruction Amendments. And it can push back against the Supreme Court on what it says the Constitution means, whether they can do this through their own forms of state constitutional interpretation, advocating for what the federal Constitution should mean, pushing for ballot initiatives. There are all kinds of ways that regular people can shift what we think of as the Constitution's meaning.
Mm-hmm. I want to delve deeper into that. But before we go there, the subtitle of your book is How Extremists Stole the Constitution and How We the People Can Take It Back. So it's clear, it's fair to say, I think, that inclusive constitutionalism is a cure for originalism. So just so we're on the same page, what exactly is originalism anyway?
So originalism is the idea that the meaning of the Constitution is fixed in time. Originalists say that it is frozen at the moment of enactment. So at the time the Constitution was ratified, at latest 1868 or so, if we're talking about the Reconstruction Amendments. But for other parts of the Constitution, much earlier than that. So in order to determine what the Constitution means today, they would say, open up your time capsule, look back and see what folks were saying in early 1800s. That could potentially be checking an old-timey dictionary to see how they define certain terms, or looking at old grammar books or newspapers, or sometimes they'll consult like political writings, like say the Federalist Papers, and say, from reviewing these, we can determine how the public originally understood what the Constitution means. And however they thought it meant then is what it means now.
Right, right. So we have to go back to the 18th century in order to understand how the founders thought about the Constitution, which, of course, is a completely ridiculous idea in the year 2024. But to be fair, originalism used to be kind of obscure, right? How did it become legitimate and now so dominant in matters of constitutional interpretation? And, along those lines, what are the goals of originalism?
So I think I would say the goal of originalism is basically to turn back time. I think conservatives essentially got the idea that if you can freeze the meaning of the Constitution, you can freeze the country as well. And so as part of a backlash to the successes of the civil rights movement, we saw this form of legal interpretation develop, saying, well, actually, anything you're advocating for now, these sort of moves by social groups, your Martin Luther Kings, like people pushing forth their idea of what freedom and liberty and equality should mean in the present day, actually none of that matters. What matters is what we think Thomas Jefferson said hundreds of years ago. So it's a way of taking ownership of the democratic project away from today's citizenry, and also outsourcing responsibility so you can sort of put blame away from yourself. It allows you to say things like, it's not that I believe this discriminatory thing. However, that's the Constitution that we have. Or if I'm faithfully applying the law as per what I assume the public thought 200 years ago, then it has these consequences for you that may be unfortunate, but I'm just an honest legal interpreter. It's not me acting out my own political biases or values. And none of that is actually true, but it provides a very helpful cover, I think.
Right, right. In the words of John Roberts, right?
Yeah.
Balls and strikes.
Balls
Just calling
strikes.
balls and strikes. So I think the most clear example, recent example, I should say, of the aims of originalism is the Dobbs decision. Mm-hmm. You argue that Dobbs is even worse than we think. It doesn't only curtail our right to have an abortion, but it's also a Trojan horse that puts substantive due process rights at risk. Tell us more about how Dobbs opens the door to more rights being taken away, and what do you think is the next right to go? So in Clarence Thomas's concurring opinion in Dobbs, he's pretty explicit about where he thinks the conservative legal movement should go next. So in the majority opinion, what Alito and the other conservatives are saying is basically substantive due process rights are too broad. And so because it can encompass a lot, we need to have a strict, narrow historical way of defining what falls within a substantive due process right. That's how they assert this idea of history and tradition as the sole defining factors. Something has to be deeply rooted in American history. Never mind the quality of said roots, but it must be deeply rooted. But Clarence Thomas actually goes a step further. He says that there are no substantive due process rights at all, and so all substantive due process decisions should be overturned. And now that includes a whole lot of rights that people hold near and dear. That includes things like the right to contraception, the right to same-sex marriage, the right to interracial marriage. So many things that I think a lot of people sort of take as a given, like, of course this is a right, of course a functioning democracy would
permit such things, if not like require that people have these things protected. But originalists say not so, because that's not how we think the public originally understood things in the 1800s. So I think that bodily autonomy in particular has a real target on its back. So there's like a direct through line from overturning Roe v. Wade to overturning those decisions I mentioned about like birth control and marriage and such. It was never just about abortion. Abortion is a big one, of course, but it was never the sole target.
Tell us a little bit more about how originalists think about substantive due process and how an inclusive institutionalist would think about it.
So I think from an inclusive constitutionalist perspective, I would try to think about what does democracy require? What is necessary for the American people to be able to participate fully and equally in the country's political and economic and social life? How do we make sure that the anti-subordination goals of the Reconstruction Amendments are being fulfilled? And so it would approach any constitutional question about whether something can be protected through that lens as, is this necessary? Like, would democracy really not function without this? Is this critical for people to be able to participate in an equal way or to shake off the caste system that has existed for so long in this country? So it's a much more forward-looking idea. In order to have a more equal and just world, what would our interpretation look like of this given provision or how this particular right might apply? Whereas the originalist idea, it doesn't look at the principle. It looks at a particular point in time and says, you know, I can turn to my historical textbook, look and see what was happening in 1800, and that's what was happening. That's what governs today. Even when I say that, I'm partly being facetious, but I'm also being a little bit generous, because if you look at how the Supreme Court has applied originalism in some of its cases, like Dobbs or like Bruin, the gun case, Clarence Thomas engages in this really absurd cherry picking through history where he will basically discard any history that doesn't fit the goal he wanted. He goes through a whole bunch of laws that were happening around the same time and says, well, those don't count because they were before the founding, which makes them too early. Or these don't count because they were after the founding and made them too late. And sure, these were at the same time, but there were only a few of them, and I don't think it was really representative of the time. And so every single thing that could go against what the Republican policy agenda was, he finds a way to cast it aside. And it shows multiple problems with originalism. One is that the idea that there is a single objective, discoverable historical meaning is kind of nonsense. Things have always been debated and contested throughout history, and that's fine. That's healthy even, as we should be debating what things mean and how to best apply them and live out these principles. On top of that, like, not only is there not a real clear historical meaning, they pretend that it gives you this objective metric, but we're seeing that he's still just sort of picking willy-nilly whatever his favorite parts are to get to the result he wants. So all it does is allow you to conceal your reactionary policy agenda.
Mm-hmm. Well, I don't know if it's concealed. I think it's pretty plain to see. We understand what's happening. I mean, I think even the most generous commentator of the Supreme Court will agree that their agenda is visible to the naked eye. So this conversation would not be complete without talking about Shelby County versus Holder, a prime example of the flawed logic of originalism and how it has already made other anti-democratic decisions from the Supreme Court possible. Aside from making the Voting Rights Act toothless, what in your mind is the most damaging downstream effect from that decision that have come since then?
That's an interesting question, because Shelby definitely did cause a lot of damage. So trying to pick and isolate a particular thing. Well, I think one of the most egregious, offensive parts of Shelby, I think, was reintroducing this idea from Dred Scott. Dred Scott being the Supreme Court's probably single worst decision, where they said it would be unfair to states if other states were allowed to recognize Black people as citizens, and where they subjugated people's rights to this sort of lofty idea of what states are entitled to, pitting the government against the people and prioritizing this idea of what states have the power to do over what people should be empowered to do. And I think that's Actually, I don't just think, I know that is the exact same kind of logic and same kind of cases that are cited in Shelby, which I found deeply disturbing. Like, literally the same cases that the Dred Scott opinion brings up to justify its idea of what they call equal footing, and what John Roberts then later rebrands as equal sovereignty. It's the exact same thing. They're talking about the same principles and manipulating them in the same way. The equal footing doctrine, as it was called way back when, basically was saying that states are admitted to the United States and become part of the Union on the same terms as other states. And this was a general principle. It wasn't actually uniformly applied, but as a general rule. That is completely different from the power of states over the people who reside in those states. And yet, both Dred Scott and Shelby County just decide, apropos of nothing, because there's no actual legal basis for this, that this idea suddenly gives states all kinds of power to abuse the rights of the people within those states. And I found it deeply disturbing, and I think we have seen a lot of trickle-down effects from that in the Voting Rights Act, as you mentioned, but also in general. I think we are increasingly seeing this idea of states having unchecked power over the people in those states at the expense of the rights that people are supposed to have and are supposed to be protected nationwide, but instead states are permitted to run roughshod over those.
Yeah, that's well put. We're taking a short break to hear about our sponsor, Shopify, and we'll be back with Madiba Dennie in a moment. But first, Thelma and Louise, Bonnie and Clyde, what about the perfect duo when it comes to growing your business? That's you and Shopify. Shopify is the global commerce platform that helps you sell at every stage of your business, from the launch your online shop stage to the first real-life store stage, all the way to the did we just hit 1 million orders stage? Shopify is there to help you grow. Whether you're selling costume jewelry or vending votive candles, Shopify helps you sell everywhere. You heard that right. From their all-in-one e-commerce platform to their in-person POS system, wherever and whatever you're selling, Shopify has got you covered. Shopify also helps you turn browsers into buyers with the internet's best converting checkout, 36% better on average compared to other leading commerce platforms. Sell more with less effort thanks to Shopify Magic, your AI-powered all-star. Shopify powers 10% of all e-commerce in the U.S. It's the global force behind Allbirds, Rothy's, and Brooklinen, and millions of other entrepreneurs of every size across 175 countries. Plus, Shopify's award-winning help is there to support your success every step of the way. Because businesses that grow, grow with Shopify. No matter how big you want to grow, Shopify gives you everything you need to take control and take your business to the next level. And that is what I love about Shopify. Sign up for a $1 per month trial period at shopify.com/hopeful, all lowercase. Go to shopify.com/hopeful now to grow your business, no matter what stage you're in. Shopify.com/hopeful. We also want to share about a podcast we think you'll enjoy called Political Gabfest.
The 2024 election means this year is going to be chock full of drama and nail-biting suspense. You deserve a politics and news podcast expert analysis, no spin, no BS. Just trusted journalists talking about what you need to know. I'm David Plotz, and each week on Slate's Political Gabfest, I sit down with the New York Times' Emily Bazelon and CBS News' John Dickerson to do just that. Join us as we unpack the latest in politics, news, and the courts. Listen to the Political Gabfest every Thursday wherever you get your podcasts.
And now, let's return to my conversation with Madiba Dennie. Well, it's clear. It's time to take back the Constitution from originalists and choose to interpret the Constitution in a way that serves all of us. There's a sense of despair, cynicism, helplessness, because we have that feeling that the Supreme Court has the last say. Now, you reject that notion and remind us that law is a construct that is subject to change and that constitutional meaning is constructed in a collaborative process between social movements, politicians, public opinion, et cetera, et cetera. In fact, you're telling us to dream big. So how can we reclaim the Constitution?
Great question. So I think a necessary first step is rejecting that idea you said that the Supreme Court has the final say. I think that a lot of people are indoctrinated into the idea that only the Supreme Court gets to say what the law is. Whatever they say goes, and that's the last word. But really, the Supreme Court doesn't have the power of the purse. It doesn't have an army. The only thing the Supreme Court actually has to enforce its decisions is everyone else deciding to go along with it. So people can decide not to. They can reject the Supreme Court's decision-making. They can put forth their own ideas as to what the Constitution means. And we have seen this throughout history. One of my favorite examples is before the Supreme Court actually declared segregation unconstitutional, we saw a bunch of civil rights activists already saying that it was and acting out their principles as if it was by refusing to ride segregated buses. We have seen ways in which the gay rights movement, for example, before the Supreme Court recognized the federal constitutional right, they said, well, I believe this is a right, and I'll go ahead and make it legal in my state, and we can work on getting it legal in all the other states, too. We have seen examples of social movements presenting their own idea of what the law means. And a successful example, but a bad example to show how, I would say, the other side has already recognized this.
Go for it.
So the right wing was furious about Roe v. Wade. And so, but even before Dobbs formally overruled the right, abortion was inaccessible in much of the country anyway, because they so successfully chipped away at Roe's protections, whether by putting forth their own ideas, like outright saying, I think Roe's unconstitutional, and so we're going to restrict abortion anyway in this way, or coming up with carve-outs where it's like, okay, I don't see a way that I can directly overturn Roe yet, but I can limit its impact if I introduce this other kind of requirement that abortion facilities would have to abide by. So it's a negative example there, but it shows the power of creative legal thinking and just mobilizing people around what they think is the better understanding of the law. Of course, I'd say they were wrong and their understanding is egregious and harmful, but it shows that you can develop your own understanding and that what the Supreme Court says doesn't just go.
Right, right. Well, in addition to curtailing abortion rights, restricting them, a lot of these states, they also passed trigger laws so that once Roe fell, abortion could be outlawed outright. And so one of the ideas that I really liked in your book was actually passing trigger laws for democracy at the state level, akin to those other trigger laws. So what would be an ideal trigger law in this moment that states should be passing?
So an example I give in the book that I enjoy is a trigger law about public campaign financing, because we have such a horrible, overwhelming influence of dark money in our elections. And we have seen the Supreme Court basically say, that's okay, that they've equated money with speech and said that any amount of money drowning out regular people's voices, that's fine. And so I think that it would be great to see states pass their own sort of money and speech regulations to try to limit the impact in spite of what the Supreme Court says. And sure, the Supreme Court will disagree, but by doing it anyway, you are articulating what you think the better version of the law is. You can rally other people around this understanding, like use it to mobilize people. And if/when you do overturn a ruling like Citizens United, you already have this legal infrastructure in place ready to go. So I think there are a lot of advantages to just going ahead and doing what you believe is the right thing, even if, or perhaps especially if, the Supreme Court says otherwise.
Mm-hmm. Yeah, I think this is the most creative way to counter Citizens United that I've heard of, because most people talk about a constitutional amendment, which would be really, really difficult to pass as an answer. But if you think about Roe being overturned, that it took 50 years and it took this chipping away at the perception that it should not be legal or should be legal either way, that it made the final decision possible.
Right.
And it made those trigger laws viable
as
waiting, like ladies in waiting, waiting to be enacted. So you have a whole section in the book with a few tactics for lay people. And we're always asking our guests to help us build our civic action toolkit. And there's so many things here. But one of the first things I wanted to ask you about is jury duty, because this kind of came out of left field.
I was hoping you would.
Tell us about jury duty. What is the opportunity for everyday Americans?
Yes. So I want listeners to know about a little thing called jury nullification. Jury nullification is one of the best kept secrets in law. And it is the idea that no matter what, if you are on a jury, you do have the right to just say no. You can choose to find a defendant not guilty. You always have that power. And I think that that's especially important for people to remember right now when we're seeing such rampant criminalization for the use of what should be protected rights, like people to have control over their own bodies and access reproductive health care, for people who are protesting. We're seeing whenever there's a social movement that the state has a problem with, the police are always who gets called in, and they always use force and violence to put these movements down and the threat of being thrown in jail. And so I think it will be really important for people to remember that if we see that happening and you're on a jury and a prosecutor is trying to incarcerate someone for accessing a right, you can say no. You can prevent that prosecution from being successful. And I know that jury duty often sucks. It's not most people's idea of a good time. But I think that there's a lot of utility there that doesn't often get spoken about.
Well, in this context of a time of protest by a lot of students, tell us a story about the Vietnam War protesters and how they essentially were exonerated by the jury, and it really set a different standard of perception among the public.
Yeah, I really thought this was an incredible story. It was about a group of protesters. A lot of them were young people. A lot of them were affiliated with the clergy as well. It's a group of Catholic leftists who were opposed to the Vietnam War. And they decided to sabotage the Vietnam War by breaking into one of the offices that the military had and destroying the draft slips. So this was a great tactic because, one, it actually works on the material level of preventing the military from being able to call up more people. So it actually does gum up the works of the draft effort. Two, I think it's symbolically powerful as well to dismantle these. But they were arrested. They had the whole group of them. It was dozens of people. They all got arrested. They faced decades of jail time and tens of thousands of dollars in fines. But they and their lawyers very explicitly called on the jury to nullify. They didn't deny that they were technically guilty of what the state had accused them of, but they said, I don't think it's a crime to prevent our countrymen from being shipped off to be killed in an unjust, immoral, and illegal war. I don't think it's a crime to oppose our government always having money for bombs and not for our schools, as they were from a dilapidated neighborhood. And they presented this evidence to the jury and encouraged the jury outright, saying, if you are with us, if you support support us, then don't convict us. And that's exactly what the jury did. And I just thought that was incredible and such a good example of protesters and community coming together, like having each other's backs and really sort of turning the tide of like what people thought the government should be doing in that moment.
Right. I think it's a perfect example to say that the court does not have the final say on how the Constitution should be interpreted. Mm-hmm. So I mentioned just now, we always ask people what advice they have in addition to serving on jury duty. What are 2 things an everyday person can do to reclaim the Constitution?
Okay, let me think for a second. Join your local union. That's a good thing or if you don't have one, form a union. I think that it would be very helpful for people to start agitating for democracy generally if we also have democracy in our workplaces. And I think it would be useful for sort of beginning coalition building, because that's essentially what a union is, right? You have a bunch of these people coming together for their sort of common goals and thinking about power imbalances within their smaller like workplace group. But I think that these are principles that apply outside of the workplace as well. So maybe it could be a good opportunity to sort of practice democracy so you can take this with you into our society more broadly. And another thing folks can do, check out your state courts and your state legislatures. They can be a source of good. They are often a source of bad. And I think state courts in particular, people are beginning to pay more attention to them now, but they have been slept on for a long time. And there's a lot of power there. That's definitely a significant close to home place where people can start influencing what the Constitution means, whether through cases that they bring or through a lot of judges are elected at the local level. So people can make the Constitution a campaign issue and say, we're not getting any originalist judges on this bench. No more.
Yeah, that's a good way. For sure, I think a lot of people still don't know that a lot of these activist cases that land before the Supreme Court start at the state level, right? And so then it goes up the ranks and goes to the Supreme Court for it to be decided in favor. And a lot of these things, as you know, of course, are cherry-picked by the Supreme Court. Like these are the things that we want to decide on and then pick them up. So speaking of joining a union and organizing together, do you see a place for a movement that is akin to building like a federalist society in favor of this kind of constitutional interpretation?
Absolutely.
Where would you start?
So I think there are some organizations that have been trying to build up things like that. There's the American Constitution Society, for example, which it's around 25-ish years old. I think I've heard them sort of jokingly refer to themselves before as like FedSoc's little younger sibling, because I think they saw what was happening with FedSoc and was like, all right, hang on. we need to develop some infrastructure as well. But there are also some newer, cool lefty legal groups. I'm thinking about like the People's Parity Project, which really tries to cultivate a lefty legal community, I think in the same way that FedSoc has done for the right. FedSoc has done so much for the right wing. But I think one of the things that we maybe don't talk about often, I know we talk about the sort of developing of a pipeline of judges, which is hugely important. And like we've talked about, like Leonard Leo's dark money web, also hugely important. But I think there's also a social function that prevents ideological drift because they have this sort of right-wing legal community watching them and that will check them. And so I think that it can help to build community in that like you have people who will stand by you so you don't feel isolated if you're making progressive decisions. And also if you misstep, you have colleagues who will then sort of call you back in and like remind you of where you went astray. And I think that we're beginning to see this develop a bit more. I think People's Parity Project is like one such group as they're doing cool advocacy, connecting with law students and lawyers around the country, trying to create this kind of space. And I know there's a group called Court Accountability that I think is beginning to do some of this kind of work as well. And I'll shout out Demand Justice as well.
They're pretty good.
Who, as a totally non-biased person.
Don't worry, we're a biased podcast. So if there's one misconception that you hear about all the time about the Constitution. What would you like to rectify, set the record straight?
That's a great question. It's a little bit hard to pick one.
Oh, but pick more than one. What are the ones you're like, oh, here it is again. There's that talking point that is just not true.
Yeah. So there are so many good ones. I think one thing that I would love to rectify is this idea that if it's not literally in the text of the Constitution, it doesn't exist, and that textualists and originalists are the only people who are doing real law and everyone else is just sort of making stuff up. I think that's a ridiculous idea that needs to be rejected outright. Because the terms of the Constitution, sure, some of them are quite specific, like the idea that you have to be 25 years old to be in the House of Representatives, or at least 35 years old to be president. But things like liberty, things like due process, or things like cruel and unusual punishment, those are exceedingly broad terms. There's not an objective meaning of that term. People should feel free to debate the meaning of that and what they think it extends to. And sort of related to that as well, I think it goes along with people saying, well, I don't see this word written in the Constitution anywhere, so it doesn't count. But the 9th Amendment, in addition to me thinking the 14th Amendment is right there with regards to liberty, I would also say the 9th Amendment is right there. The 9th Amendment literally says that just because it is not an enumerated right doesn't mean it doesn't exist. That's one thing I would give the founders, in that they identified a bunch of rights by name, but one of them had to have had the bright idea where they're like, wait a second, maybe if we're listing all these, someone will think that these are the only rights. We should provide a caveat. And so they did provide a caveat. It's called the 9th Amendment. And it says that this enumerated list doesn't mean that because it's unenumerated, it doesn't exist. And yet we hear that all the time. People saying, well, this isn't there, and so it doesn't count. And I think that's nonsense and serves to suppress social movements and the kind of work that they would do to fight for the rights that they believe aren't being recognized. And this one's more of a smaller scale pet peeve thing, but the idea of people just invoke the First Amendment without regard for what the First Amendment actually means. Like, you can tell somebody to shut up and they would say, I have a First Amendment right. And it's like, that's about the government forcing you to stop speaking or censoring you. It doesn't mean that I can't tell you that I think what you're saying is a load of crap. Like, blocking you on Twitter is not a First Amendment violation.
Right. Yeah, people don't know that.
They really don't. I feel like I hear that too often. It's like, oh, you have to engage with me because of the First Amendment. And it's like, actually, my First Amendment means that I can choose whether or not to.
Yes, yes, exactly. Yeah, we agree there, 100%. So as we're closing out our conversation here today, looking into the future, what makes you hopeful?
Well, I think that's something that gives me a lot of hope, even as dark and as trying as these times are, is to remember that there have always been dark and trying times, and that people have fought all the same. And often people have won all the same, even though we have these formidable obstacles. I think that there is strength in remembering that law is a construct that is subject to change, because it means we can be the agents of that change. And I think there's power in remembering our community. This is maybe a little bit corny, but I really think it's true that the people united will never be defeated, and that collectively we can always fight for a different way forward.
Mm-hmm. Yeah, totally agree. It's a good reminder that justice is not a destination. It's an ongoing work that all of us have to engage in. Mm-hmm. Thank you very much, Madiba, for joining us on Future Hindsight. It was really a pleasure to have you on the show.
Thank you. This was a lot of fun.
Madiba Dennie is the author of The Originalism Trap, How Extremists Stole the Constitution and How We the People Can Take It Back. Next week on Future Hindsight, we're joined by Rachel Vindman. She's the co-host of The Suburban Women Problem and has her finger on the pulse on all things politics for American women. That's next time on Future Hindsight. And before I go, first of all, thanks so much for listening. If you like this episode, you'll love what we have in store. Be sure to hit that follow button on Apple Podcasts or the subscribe button on your favorite podcast app, so you'll catch all of our upcoming episodes. Thank you. Oh, And please leave us a rating and a review on Apple Podcasts. It seems like a small thing, but it can make a huge difference for an independent show like ours. It's the main way other people can find out about the show. We really appreciate your help. Thank you. This episode was produced by Zach Travis and me. Until next time, stay engaged.
This podcast is part of the Democracy Group.